Meet Alistair Mctaggart, a San Francisco real estate developer who gets involved with Californian privacy issues. One night, over pizza and wine, he asks a Google developer should he be concerned over how much they know. The developer's reply shocked him. It started Alistair thinking about tech companies, how they track and mine personal information. He learnt the United States has no single comprehensive privacy law regulating the use and collection of personal information. Alistair discovered companies create their own data collection rules and protocols. Thinking something ought to be done, Mctaggart wondered if he should be the one to do it. First, he considered proposing a new state privacy law. His friend Rick Arney suggested a different approach. Why not ask the people directly, via signatures on a statewide ballot initiative? Mctaggart liked the idea, so in 2017 he set up a small office. Staff included Ashkan Soltani, a prominent privacy researcher. Alistair cold-called privacy experts to determine what his privacy initiative should say. After 6 months and many drafts, it was ready. Mctaggart's ballot initiative was submitted in November 2017. Signature collection commenced early in 2018. In February, the opposition committee formed. It included companies like AT&T, Google, Facebook, and Amazon. Big tech was hitting back hard. But in March 2018, the Cambridge Analytica scandal broke. Privacy was now on everyone's mind. Getting signatures became easy. On May 3, 2018, 629,000 signatures were submitted, almost double the legal requirement. Later that month, Mctaggart met Senator Bob Hertzberg and Assemblyman Ed Chow, wanting to do a deal by taking the ballot off the table in exchange for passing a law he liked. Initially, Mctaggart wasn't impressed. The drafts lacked enforcement. A week before the deadline to pull the measure off the November ballot, the real negotiations began. On one side was Mctaggart and his team. In the middle, the legislators. On the other, big tech. Over a crazy weekend, Mctaggart retained the right for consumers to see all their information and the children's 13 to 16 opt-in. But he pared back on consumers' right of private action. Finally, opponents were told, take it or leave it. After a pause, big tech blinked. Mctaggart's wife Celine sent him off to Sacramento to lobby hard. So he spent 3 days walking the halls, talking to legislators. The AB 375 vote was on June 28. Mctaggart watched from the public Senate gallery as the bill passed unanimously in both houses. Of course, this wasn't the end. During 2019, opponents tried gutting the bill. At the time, Mctaggart called it a great stride forward. If it happened here, he said, it will happen in the rest of the country. The Californian Consumer Privacy Act 2018, known as the CCPA, is the most significant data privacy legislation ever enacted in the United States. It establishes new rules governing how businesses handle personal data throughout California. Companies storing large amounts of personal information must disclose the types of data they collect, the purpose for data collection, how the data will be used or processed, and ensure consumers can opt out of having their personal data sold. The CCPA also expands organisational responsibilities around individual rights, accountability, and governance. The CCPA's timeline is short. It was drafted and passed in haste. The business community has criticised legislation and its rapid introduction. Keeping up with the CCPA, It's like chasing a moving target. During 2019, the California legislature tried fixing flaws caused by its rushed enactment.